warm welcome to all the participants attending this webinar on the new normal, the impact of COVID-19 on the arbitration landscape in India. Thank you everyone for taking your time off to be with us today. Depending on which part of the world you are in, we wish you a very good morning, afternoon or evening to you. Ladies and gentlemen, India is in the middle of an extended lockdown. Lockdown 2, as they call it, until May 3rd. Many other countries are in similar situation with restrictions and lockdowns. These are indeed challenging times, but in particular for our frontline warriors across the world battling out to keep us all safe. So before we start, let's take a moment to think about them and thank them for the relentless and untiring efforts. Let me, at this juncture, introduce myself and my co-panelists. I am Arun Chawla, and I am the Deputy Secretary General of FICCI, the apex chamber of commerce and industry in India. As a nominee of FICCI, I am on the governing board of the Indian Council of Arbitration, which is in short called the ICA. ICA is an allied body of FICCI, and I am also served as the executive head of the ICA. I am also joined by Mr. N.G. Khaitan and Mr. Sanjeev Kapoor, who are partners in the dispute resolution practice of Khaitan and Company. Mr. N.G. Khaitan has, over his career spanning several decades, advised and represented clients on numerous notable transactions in all areas of practice, including arbitration, civil and commercial litigation, competition and antitrust law, to name a few. He regularly advises prominent industrial houses and multinational corporations on a plethora of legal matters. He is also the president of the Indian Council of Arbitration and a national committee member of FICCI. Mr. Sanjeev Kapoor has over 20 years of experience in representing group companies, MNCs, and private equity firms before domestic courts as well as in international arbitrations. He regularly advises on the complex cross-border litigations, disputes arising in the private equity and venture capital space, as well as on litigations in the infrastructure, banking, and securities sector. So without any further ado, let me introduce the agenda for today's webinar. Next slide, please. The arbitration community across the world has always welcomed innovations in technology with open arms. It would not be wrong to say that the stakeholders in the arbitration community have been a step, or rather 2 steps ahead of courts when it comes to adopting novel techniques to increase efficiency and save time and costs. However, unfortunately, the present situation is completely new and has taken everyone by surprise. Ensuring business as usual is not going to be easy, even for the savvy arbitration community. However, it is widely believed that arbitrations are far better equipped to minimize the disruption from this crisis rather than the traditional litigation. But the million-dollar question is, are we really prepared? Is India really prepared to adapt, or do we still have a long way to go? We will start today's session by analyzing the extent of the impact caused by the pandemic, particularly from the point of view of arbitrations in India. Lots of questions in everyone's mind. How long will this last? When will courts, tribunals see normalcy? What are we looking at in terms of the future of dispute resolution in India? We will try to address some of these issues. We will then discuss how courts and particularly arbitral tribunals have responded in India, and whether we really geared up for a few months of restrictions, if not complete lockdown. The question really is whether we can afford to continue the status quo, and if so, for how long. In this respect, we bring you from our experience a sneak peek into the response by courts and tribunals across India. We will also, in the next 40 minutes or so, look at the present situation from an international perspective. How have international arbitral institutions responded? That said, we will also evaluate whether we are in India equipped to switch to completely virtual processes right from filings to hearings. Do we have the infrastructure and technology to efficiently manage this transition? From a practical perspective, we will discuss how this crisis and the delays caused on this count will impact ongoing and future arbitrations. What happens to the timelines for completion of the arbitration proceedings? These are some of the questions that come to our mind. We will also examine the future of arbitrations in India. What is it going to be like in the post-COVID-19 era? Are we all gearing up for, as they say, the new normal? Lastly, we will also take up some questions from the audience. Before I proceed with the webinar, let me explain the format for today's webinar. This webinar has been set up as an interactive session. You can submit questions online at any time during the webinar and in the question answer session at the end. The speakers will first cover the agenda in around 45 minutes, and then we'll take the question answers, which will provide you with an opportunity to raise issues of importance to you. To submit a question, simply use the facility provided in the webinar portal. We will endeavor to answer as many questions as we can. If we cannot answer all questions, we will do so offline by email. Also, please note that a copy of the presentation will be sent to you after the webinar. Next slide, please. Now, we start by examining the fallout of the present crisis from a disputes point of view. As mentioned earlier, the lockdown in India stands extended until May 3rd. We have seen a similar response in several other affected countries. As a natural consequence, it is expected that the disruptions in the domestic and international supply chains are likely to continue. The situation, I must emphasize, is indeed quite incredible. From an Indian point of view, by the time this lockdown ends on May 3rd, and assuming it does, India would have been in a lockdown for no less than 40 days. This fact is in itself enough to explain the catastrophe unleashed by COVID-19. What do we expect then will be the future? Naturally, there is a strong likelihood of a rise in the number of disputes, particularly from a contractual point of view, and more industries and companies not being able to service their debt obligations. I'll take an example, the construction and engineering sector. If the activities do not return to normal very soon, it is likely that many parties will have no option but to seek termination, renegotiation of the respective contractual obligations. One thing is very clear, we will continue to hear the expressions force majeure, frustration of contract, a lot in the next few months. Another interesting aspect worth consideration is the response by courts in this situation. While there have been a spate of decisions from the Delhi High Court and Bombay High Court granting interim protection to borrowers against security enforcement and asset downgrading, it is important to note that this is a very small subset of disputes likely to arise, and these decisions are merely band-aids to protect borrowers in the interim. There is very little precedent on how the courts will react in the aftermath of this crisis. However, presently we must not forget that with the lockdown in force, courts and tribunals are presently not completely functional. The natural question is, who will hear the disputes then? Certainly, there is an urgent need to devise a mechanism to hear and give importance to commercial disputes, particularly given the uncertainty prevailing around the lifting of restrictions. We will examine this issue in further detail in the course of this presentation. Next slide, please. Impact on courts and arbitral tribunals. When we talk about the impact of this crisis on the functioning of courts and tribunals, at least from an Indian point of view, it is clear at the moment that the situation is far from normal. And the same goes for courts in other countries as well. In India, the Supreme Court is only entertaining very urgent matters with limited benches via video conferencing. This is also the position with high courts across the country. The high courts have made an attempt to follow the lead of the Supreme Court in ensuring that urgent and important matters get a hearing as soon as possible. It must, however, be said that while there are talks about institutionalizing the use of technology in the future, at present, the courts in India are not equipped to function at full capacity. Ladies and gentlemen, there is no denying that there have been certain very encouraging steps, and the courts in India have not been blind to the present situation. E-filings, mentioning via telephone, relaxing technical requirements, hearings via video conferencing, encouraging the use of popular platforms like Zoom, LifeSize, etc. in case of linkage issues are only some such steps. Recently, the Supreme Court also issued detailed guidelines on the use of video conferencing. This will be discussed in greater detail over the course of the webinar by my fellow panelists. Interestingly, I also heard that the Supreme Court of the US has also taken steps to hear matters via teleconferencing. However, these are only interim measures. One thing is clear. The situation will not improve overnight, and it will take several weeks, perhaps months, to recover entirely. We must, however, work towards restoring normalcy at the earliest, though the standard and extent of normalcy in these situations is itself debatable. What we need is a complete metamorphosis, a complete transformation in the manner in which we look at dispute resolution in India. This is a lesson that there is an urgent need to look beyond what are conventional methods of conducting not just arbitration, but generally dispute resolution in India. We cannot allow the crisis to hold us to ransom indefinitely. In my view, ladies and gentlemen, there are three A's we need to look at in the current situation: adjust, adapt, and acclimatize. And I recall the old saying in this regard: change is the only constant. At Indian Council of Arbitration, we have begun the process of taking consent from arbitral tribunals, parties, and other stakeholders for conducting the hearings through video conferencing. We will also shortly begin the process of registering new cases through the online process. There will be some challenges initially, but I'm sure we will overcome. With this, Ladies and gentlemen, I invite my fellow speaker, Mr. Sajeev Kapoor, to take forward the presentation. Thank you. Sanjeev, over to you.
I'll just interrupt. Sanjeev, you need to unmute yourself, please.
So these are the perils of sometimes adopting to technology. So, Mr. Chawla, so let me start by sharing as to how the arbitral tribunals in India have responded to present crisis. As rightly highlighted by you, even the arbitration community in India and in fact across the world has been at the receiving end of the present pandemic. Over the last few weeks, in our experience, the functioning of the arbitral tribunal has been derailed. We have seen deferment of several scheduled hearings which were planned many months in advance, leading to a difficult situation since it is not always easy to find new dates with the hectic calendar of counsels and arbitrators alike. In particular, the deferments have been a hallmark in cases where evidentiary or final hearings were scheduled in these weeks. Now, this is obviously likely to result in delay, which is simply unfortunate, but it seems unavoidable in these circumstances. In some cases, however, we have seen arbitral tribunal proceeding with the hearing on a virtual basis. Procedural hearings such as case management conferences have in particular been held over teleconferencing, which is obviously a very wise thing to do, especially if the parties do not have difficulty or objections. Mr. Chawla mentioned steps ICA is taking to mitigate any loss of time because of this situation. Another matter in our experience was that where the parties were due to file evidence, extensions were sought primarily on the grounds that the party representatives were not available to confer for finalizing evidence. Similarly, in another matter, a party sought an additional 6 weeks to file the statement of defense again, citing the lockdown in India. It must also be said that, in our experience and expectedly so, the tribunals are at a moment dealing with the extension requests leniently. As we all know, this is completely unique situation for everyone, and therefore this sort of leeway was not entirely unexpected. From the tribunal's point of view, there is also the aspect of delay in rendering awards in matters where the hearings have concluded. The disruption and lockdown mean arbitrators have not been able to consult each other while writing the awards, or in some cases, arbitrators do not have access to their own office. In summary, there is no doubt that there is a lot of confusion and uncertainty at the moment. However, this cannot be and should not be allowed to carry on indefinitely, and all possible efforts must be made by stakeholders, tribunals, parties, councils, and arbitral institutions to minimize the disruptions by continuing to work remotely as far as possible. The one advantage with arbitrations, unlike unconventional courts, has been that the entire setup is not inflexibly formal and accommodates a great amount of flexibility based on principles of party autonomy and consent. Under the Indian Arbitration Act, the tribunal is also free to devise its own procedure. In such circumstances, we must use this opportunity to leverage available technology to find ways to continue uninterrupted progress of arbitral proceeding through virtual filings and hearings. This is the time when the community needs to stand up and set up an example for everyone to follow. How we can do that and whether we are equipped to do that are questions we will answer in the course of this webinar. On delay and deferments, there is another aspect to be considered. Section 29A of the Act fixes time limit for conclusion of arbitral proceedings. Presently, the arbitration proceedings are required to be concluded within 12 months. This time period can be extended by further 6 months by party consent. Any further extensions require an order from the court. The question then is whether relief ought to be granted by courts by extending these timelines given the time cost and time lost on account of present crisis. In my view, this is a double-edged sword. Recently, the Allahabad High Court has granted an extension under Section 29A to parties looking at extraordinary circumstances. The High Court has directed that in matter where pleadings have been completed under Section 23(4) and the period of 12 months have expired or was going to expire on or after 25th March 2020, then the same shall stand extended up to 25th May 2020. Now the jury is out on this one. One view is that extension are necessary given the uniqueness of the situation, as the High Court put it, extraordinary nature of the situation. Another view is that extension must be considered, but on a case-to-case basis, and must not be granted en masse, as was done by Allahabad High Court. In my view, the courts must be wary of possibility of parties using this time as an excuse to delay proceedings, without even making an attempt to minimize the disruption by using means available at their disposal. Now, moving on to the next slide. I think it's very vital and important to consider and examine how responding certain prominent arbitral institutions across the world has been to deal with the present pandemic. Mr. Chawla told us as to what ICA is doing. The role of an arbitral institution becomes particularly critical in circumstances as present to avoid unnecessary delays. The institutions can play a key role in providing the necessary infrastructures and platforms to the parties should they wish to conduct hearing by virtual process. Parties themselves may not always have the knowledge or wherewithal to adopt to such an unfamiliar process. The institutions, with the experience and resources available at their disposal, are capable of ensuring a seamless transition from the parties. Let us, from the perspective, look at the steps taken by some of the institutions worldwide. It is remarkably evident that these institutions have responded very efficiently ever since the crisis peaked in March 2020, even in times as challenging as these. Most of them, despite working remotely, have responded promptly, and almost all have issued detailed guidelines and advisories for parties, assuring them that they are fully equipped and operational. Some of them have also issued guidelines for conducting remote hearings. It was not uncommon even before this crisis set in to see filings via email in arbitrations. However, in the present situation, these institutions have strongly advised to correspond only via email, temporarily dispensing with the need for any hard copy documents. We keep talking about the requirements to continue business as usual. The efficient response by these institutions in these times will go a long way in inspiring confidence among the community. I also feel that there is something in here for Indian arbitral institutions to learn, adapt, and also follow. There are a few active and sought after arbitral institutions in India as well now, including ICA, and their response in these times will reflect how equipped we are as an arbitration community in India to tackle the crisis. We heard Mr. Chawla, as he did point out, that ICA is taking steps in a very proactive manner to help the arbitral community tide over this crisis. While we are on this subject, I would like to highlight an interesting episode which has a very encouraging message for all of us. Owing to the pandemic, the organizers of Vis Vienna Moot, which is one of the oldest and most prestigious moot court competition in the world, decided to host the oral rounds virtually, and the final was conducted on 9th April 2020. What is most astonishing is that the competition, despite being virtual, one this year, saw participation from 248 teams. In my view, to manage and pull off this event seamlessly with such massive participation was simply outstanding. There is certainly a message in there for the arbitration community, and leading commentators across the world have cited this example to argue that the technology and infrastructure is certainly available as long as parties are willing to move forward. This was far more difficult than a conventional arbitration where the participations are limited. Now, moving on to the next slide. I think the real question then is, are we in India really equipped to switch to and adopt virtual processes? In my view, in order to answer these questions, 4 key aspects are required to be considered. And first and foremost among them is technology. The crisis has made us realize that the availability of technology and infrastructure is a boon in overcoming hurdles caused by lack of physical presence. The crisis has also shown us that geographical boundaries are no longer a barrier. Many platforms, old and new, are available to seamlessly conduct virtual meetings and hearings, right from government functionaries to private offices. The consistent feedback is that transition is not difficult, and it has to do more with the mindset of stakeholders adopting the same. One of the most underutilized provisions, in my view, of the Arbitration Act is Section 29B, which permits fast-track arbitrations on documents-only basis. Encouraging parties to resolve disputes via document-only arbitrations, particularly in cases which do not necessarily require oral evidence, is a very critical tool in journal, and especially so in times as these. This is a particularly useful tool for disputes that is not high value or complex in nature. As mentioned earlier, arbitral institutions in India will play a key role. An increasing number of parties are opting for institutional-based arbitrations. In fact, the 2019 amendments to the Arbitration Act emphasize the thrust on this aspect. These institutions, including ICA, are taking lead and spreading awareness about the ease associated with technology. Present webinar is also a step in that direction by ICA. Stakeholders need to be assured that the technology is very advanced and concerns are negligible. As Mr. Chawla pointed out, courts are also playing a key role in inspiring confidence among the community. The Supreme Court has already led the way, overcoming technical and procedural formality. The Supreme Court has made arrangement and issues guidelines for mentioning of the matter by telephone, on filing, hearings by video conference are being conducted. In fact, only yesterday, the Supreme Court issued another set of guidelines in respect of the procedure to be followed for listing of extreme urgency matters via video conferencing. The guidelines also provide stepwise details of the procedure to connect and the manner in which the proceedings are to be conducted via the video conferencing. Led by Supreme Court, several High Court across the country have responded to lockdown efficiently and with elasticity with a view to ensure access to justice. We see orders coming out on a daily basis from these High Courts deciding issues of urgent and emergent nature. In fact, Delhi High Court only yesterday increased the number of benches hearing matters virtually. So this shows we are equipped. The only question is willingness and acceptance. We must look to be prepared to deal with any eventuality in future and adapt as quickly as possible to the new norm. Now, moving on to the next slide. So while there is no doubt that technology is indeed the future of arbitrations in India and across the world, there are some challenges and concerns which, if addressed, can certainly encourage more and more arbitrators, lawyers, and parties to make use of technologies in conducting arbitration, thereby greatly enhancing time and cost efficiencies. A survey conducted by Queen's Mary University in association with White & Case on international arbitration in 2018 returned some very useful and interesting findings. Views were sought from a diverse pool of participants in international arbitration, including in-house counsels, arbitrators, private practitioners, and arbitral institutions, academics, experts, and also third-party funders. On to aspects of technologies, here are some interesting findings. Due process paranoia was found to be the main reason that user believed was preventing arbitral proceedings from being more efficient. Participants believed that an increased use of technology would lead to more efficiency. Overwhelming number of participants favored the greater use of technology. Virtual hearing rooms, cloud-based storage, video conferencing, and artificial intelligence were preferred. 61% thought that increased efficiency, including through technology, was likely to have a significant impact on future of international arbitration. While the findings are extremely positive and encouraging, there are also some concerns, as is evident from the pie chart on the present slide. 78% of the users indicated that they had either never or rarely used a virtual hearing room. Virtual hearing rooms these days provides much more comprehensive solutions, provide facilities such as remotely managing the video link, deploying documents from electronic hearing bundles, options for real-time transcripts, etc. These facilities are far beyond what video conferencing can offer. Even here, though, an overwhelming majority suggested that video conferencing, 89%, cloud-based storage, 91%, and hearing room technologies, 98%, are tools that arbitration users should use more often. This is an encouraging finding. Many users, however, also expressed reservation as to effectiveness of conducting cross-examination or closing arguments via video conferencing. Some arbitrators highlighted that for such hearings, they insist on physical attendance. In my view, the findings are broadly very positive and encouraging. Despite concerns, they consistently indicate that users believe in the use of technology to make arbitrations more efficient. Moving on to the next slide. Some other challenges and concerns of stakeholders are linkage interruption. There are concerns around possibly connectivity issues and interruptions with many participants joining from different, sometimes remote locations. Confidentiality is another major concern for stakeholders. The another area of concern was evidentiary hearings. As stakeholders have highlighted, questions remain about efficacy of cross-examination on video conferencing. Factors such as body language, tonal changes, facial expressions of witness play crucial role sometimes, and these may not be very clear on video conferencing. External assistance to witness in the form of coaching or reading from a script outside the camera view also remains a concern. Many arbitrators have opined that loss of in-person observation of witness testimony will impair their ability to form an opinion on the credibility and strength of the evidence. However, technology can provide answers to such concerns. In fact, there are detailed guidelines and protocols which deals with such aspects. Moving on to the next slide, please. Yeah, this is a slide. One such protocol is Seoul Protocol on Video Conferencing in International Arbitrations, which you see on your screens. The protocol could be a very useful reference point as it seeks to establish a framework covering the best practices to be adopted in the use of video conferencing. The Seoul Protocol must not be mistaken to be some kind of a hasty reaction to the present pandemic. It was drafted sometime in the year 2018 in association with Seoul International Dispute Resolution Center and is intended to serve as a guide to best practices for planning and conducting video conferencing in arbitrations. The usage of video conferencing in international commercial arbitration increases. The questions which come up is whether we have the right tools to minimize or eliminate the risk associated with this technology. This question led to drafting of Seoul Protocol. These risks are addressed quickly given the entry of various new players in the market. These players seek to make the technology more affordable. Some privacy and security concerns have already been raised in respect of growing use of popular video conferencing platforms, particularly in this pandemic. As we will seek to highlight, there are many useful features in the protocol which we could adopt and implement for conducting arbitrations in India. Given the time restriction, I'll not touch upon each and every feature of these protocols and urge you to do the same at your leisure. However, the protocols and guidelines clearly identify and then address many of the concerns which have been bothering arbitral tribunal and suggest effective and practical ways to resolve them. Detailed protocols will take away the procedural headaches of the arbitral tribunal as to how to conduct the virtual hearing. Moving on to the next slide. Another important protocol, and which is very recent one, is concerning cybersecurity. This is Protocol for Cybersecurity in International Arbitration 2020. A lot of stakeholders tend to make the mistake of not taking cybersecurity issues in arbitration seriously. I'm reminded at this stage of an incident in the year 2015, as reported in press, that the website of Permanent Court of Arbitration in Hague was hacked during the hearing of a sensitive maritime border dispute between China and Philippines. It was also reported the websites of Philippine Department of Justice and law firm representing the Philippines were also hacked. I am sure you can all imagine the consequences of losing sensitive data concerning a border dispute to hackers. This protocol is the Protocol for Cybersecurity in International Arbitration and seeks to provide a framework to determine reasonable information security measures for individual arbitration. It includes procedure and practical guidance to assess security risk and identify available measures that may be implemented. The protocol also touches upon various areas of concern in cybersecurity space that all stakeholders need to pay attention to, including increasing awareness about information security risks in the arbitral process, the essential role played by the individuals involved in the arbitration, and effective risk mitigation measures available to improve everyday security practices. The protocol itself provides that even though it has been drafted with international commercial arbitrations in mind, it may also be a useful reference tool for domestic arbitrations. A very brief outline. The protocol considers some very baseline security measures forming part of Schedule 8 of this protocol. These measures are non-exhaustive checklist of general measures on knowledge and education, asset management, confidentiality, access control, and also for providing a information security incident response. So while it is important to encourage the use of technology, these are concerns that a party would ignore at its own peril. With sophistication and advancement in technology, we are witnessing an increasing number of incidents of phishing, hacking, and other cybercrimes. Adherence to protocols like this will help you protect against and mitigate such concerns. Now, moving on to the next guideline, which you see on screen, is in respect of witness conferencing in international arbitration, framed in April 2019 by the Chartered Institute of Arbitrators. These guidelines are offered as a practical document for use by arbitrators and experts in preparation for and presentation of evidence by witness in conferences. The guideline provides a very helpful checklist for parties and tribunals to consider in determining whether witness evidence may be taken by video conferencing. You must have noticed all these guidelines and protocols have a specific focus on recording of evidence by video conferencing, since that has been the most challenging aspect in recent times. As mentioned earlier, it is not uncommon for procedural hearings to be via virtual processes. However, concerns come up at the time of recording of evidence as well as the stage of final hearing. Now, moving on to the next slide. We look at the ICC report on IT in international arbitration released in the year 2017. I'm going to briefly discuss some of the suggestions from this very useful report. The report discusses the usage of information technology at various stages in a typical arbitration proceeding. Like all other reports, this report also recommends the usage of video teleconferencing, electronic exchange, transcripts while keeping in mind security and confidentiality considerations. So in summary, these are some of the useful guidelines and protocols, and the Indian arbitration scenario would certainly be richer if we could adopt and implement some of the recommendations while making the switch to technology. I do personally that we will have a set of guidelines customized for India sometime in the future, especially given the growing concern and awareness about data privacy in India. Now, moving on to the next slide. We look at a very recent report by ICC on measures to mitigate the effect of COVID-19 from an arbitration perspective. The guidance note serves as a very useful framework and do's and don'ts to be adopted by parties in this scenario. The focus of the report is on minimizing the disruption to be caused as a result of this pandemic. The note suggests that several measures in the form of remote hearings, document-only arbitration, e-exchange, preparation of cyber protocol, and how to sensitive data. From an arbitrator's point of view, the report recommends that this time can be used to consult co-arbitrators via virtual processes and prepare draft awards in matters which have already been reserved. The report also recommends identifying if the matter can be decided and resolved only on the basis of, or if the inspections by experts can be replaced by video conferencing with a view to save time and maintain continuity in these times. I think the note serves as a very useful guide, paying attention to detail and dealing with minute issues that parties may face during this period. Certainly, tribunals and parties seeking to arbitrate during this time may use this guidance note as a reference point for addressing any technology-related concern. Now, moving on to the slide. So, what are the final takeaways? And what are we looking for future of arbitration in India? What will happen after COVID-19? Are we going to go back to pre-COVID-19 times? While it is difficult for anyone to accurately predict the future, given the uncertainty and peculiarity of situation, we expect the following. The future is uncertain. However, the only certainty is that this is going to be the new normal. Technology is here to stay. We expect to see extensive use of video, teleconferencing, physical hearings, at least for and less substantial matters, could very well be a thing of past. The popularity of tech-savvy arbitrators is likely to go up. Given increasing cost and time considerations, arbitrators refusing to adapt are not likely to figure in the parties' choices at the time of nomination. With advancement of technology, time and cost efficiency benefits are expected to be remarkable and likely to intensify acceptability of virtual processes as effective time and cost solution. To keep pace with world, India must adopt international best practices on virtual proceedings. Therefore, it is time for Indian arbitral institutions to step up. This pandemic is the perfect opportunity for them to rise to the occasion. We would expect to see an active guidance on these points for Indian arbitral institutions, who are likely to be the driving force for commercial arbitrations in India in near future. It is very encouraging to see that Indian arbitral institutions are keeping pace with the world and taking steps to adopt the technology, as has been pointed out by Mr. Chawla for ICA. While 29A examples may be a necessary facet in some of the proceedings, courts should be wary of overusing of the exemption, which may defeat the very object and purpose of the parties adopting alternative dispute resolution mechanism, such as arbitration. Parties should be incentivized to strive for greater use of technology and to minimize delays. However, tribunals should ensure that all their procedural orders adopting such measures are sufficiently detailed and well reasoned so as to avoid any risk of challenge to the enforceability of the ultimate award. With this, I will hand over the presentation to Mr. N.G. Khaitan, who will share his views on the topic with you.
Thank you very much, Sanjeev. Today I want to speak not as a lawyer, not as a partner of Khaitan and Company, but as a president of Indian Council of Arbitration. In fact, I will be speaking little off the cuff, and I would like the participants to give their views on whatever I express that the ICA should do, or the institutions, arbitral institution in India, the policy the arbitral institution in India should adopt. My personal feeling is that today we are going through a financial emergency, and in case of this financial emergency, the arbitration is a very important tool. Why I say so? Because with this COVID-19, there would be a lot of litigation relating to termination of contract, in relation to force majeure, in relation to defaults which the parties are likely to commit in view of the financial stress which they may suffer, or which they are suffering, and which may undergo. So in that view of the situation, it is very likely that there would be a rise in number of cases and the parties would resort to arbitration. Now, what should we do at this moment when there is a financial crisis? The parties would need two things from the people who are dealing with the arbitration matters. One is to cut cost, and another is to avoidance of delay. Now, how do we achieve it as far as the cutting of cost is concerned and avoidance of delay is concerned? Now, there are a number of exchanges, associations, where the disputes between the members of these between the members of this association, if there is a dispute, then the association appoints an arbitrator, and only the parties are allowed to appear before the arbitrator. None of the lawyers are allowed to appear before the arbitrator, and the arbitration is basically on a fast track mode. Therefore, I would like to have views from all concerned parties. What should we do in the facts and present facts and circumstances? Should we have a procedure where there would be a fast track arbitration with a threshold limit, pecuniary threshold limit of rupees 1 crore or 2 crores or 3 crores? We can decide on those particular threshold limits, monetary limit, and we should adopt for a fast track arbitration, and there should be an arbitration to the sole arbitrator only, and the arbitrator should be instituted by the institution who appoints a sole arbitrator. because the parties would not likely to agree on an appointment of a sole arbitrator. The other suggestion which you would like to put in, that as far as should we now have the policy of arbitration through free arbitrators, because one party appoints an arbitrator, the second party appoints an arbitrator, and then two arbitrators appoint the third arbitrator. And we have always seen the tendency that the arbitrators tends to have little bit of bias towards the parties appointing them. So therefore, in order to avoid cost and in order to avoid the delay in the arbitration proceeding, should we not consider that in all arbitral proceedings, instead of having three arbitrators, we should have one arbitrator, or we can have a threshold limit that on a dispute beyond 500 crores of rupees or 1,000 crores of rupees or 100 crores of rupees, there will be only a sole arbitrator, and the parties will not have a choice to appoint their arbitrator. This was one of the issues which I felt we have to consider in order to avoid costs. Now, if you appoint a sole arbitrator, then the question is whether that particular arbitrator has acted in a bias in giving the award, or whether there was a question of his integrity. Now, how do you avoid that? Because the challenge to the award is very, very difficult, as in a very, very limited ground. So if the challenge to the award is on a very, very limited ground, the integrity of the arbitrator is very, very important as far as the sole arbitrator is concerned. So therefore, my personal feeling is, if we could have a policy that as far as when a sole arbitrator is appointed, and if a particular party feels that the arbitrator has had a bias towards passing of an award, then that particular award could be examined by a panel of experts. And if those panel of experts can feel that this particular award had an element of bias into that, then we can have a provision for blacklisting of that arbitrator. Now, if you blacklisted a particular arbitrator, the chances are that a particular person who has acted as an arbitrator, he would act with total integrity. And in case it is found that the arbitrator had no bias and the award was fair and reasonable, then the party who has complained the award should be liable to pay the damages to the arbitrator because his reputation has been affected. Now, these are new novel ideas which I have, that how should we avoid cost, eliminate cost, and have a fast track arbitration. Now, as Sanjeev was rightly saying, that arbitration through video conferencing, I also feel the time has come when we should incorporate in our arbitration agreement that the arbitration will be through digital mode, and we should also incorporate in our arbitration agreement that the arbitration will be to the sole arbitrator to be appointed by a third party. It can be an arbitral institution or it can be anybody, whoever the parties decide. Therefore, we have to, in this situation, we have to think of novel ideas, new ideas, and not go by the current way in which we are doing arbitration and which we are arbitrating. The point in issue is that this is a new world. In this new world, we have to face a new reality, and in this new reality, we have to say that how we can give relief to the party at the minimum cost and with the in an expeditious manner. These are the few points which I felt that the Indian Council of Arbitration should consider. But the other off the cuff thing which I want to make is that today all the parties are going through a lot of financial stress. Now, if there is a financial stress, then how do we give a relief to the party who is in a financial stress? Now, the Singapore has recently come out with a law, which law is known as a Singapore Temporary Measure Act 2020, which came in just a week back, and where they have suspended the legal proceedings, the continuance of the legal proceedings, and the commencement of the legal proceedings and the continuance of the legal proceeding, as well as the arbitral proceedings, both for a period of 1 year. And the only exception is the international arbitration. Now, why they have done it? That because of this financial crunch which all the persons would be facing in this COVID-19, whether the parties concerned would be able to bear the cost of arbitration, whether if the award goes against them, whether they would be able to make payment in terms of the award, and if they want to challenge the award, whether they would have sufficient funds to ask for the stay of the operation of the award. Now, this is one area which we have to look into, that whether in this COVID-19 situation, whether we should ask for the continuance and suspension of arbitration proceeding. So you will agree that a lot of countries have passed a law that will be a suspension of insolvency proceedings. There will be a total suspension of insolvency proceeding. In fact, India is also has increased the threshold on the institution of the insolvency proceedings, and they are also contemplating that there will be a suspension of insolvency proceedings. So this is a thought process which is going on with the government, which is going on with different authorities as to what we should do. In fact, in some of the countries, they have said that there will be a moratorium on the enforcement of the security, that there will be enforcement of bank guarantee, there will be suspension on the enforcement of the bank guarantee, enforcement of the security, because it is a financial crisis and the persons concerned will not be in a position to pay. So I would also like to have views of all our participants on the issues which I have raised, which I think are very important issues. And in relation to this coronavirus COVID-19, I think these issues required to be looked into, required to be considered. And as the President of Indian Council of Arbitration, I'll have to take a view as to what we should do in order to give the relief to the parties who are arbitrating, both for the claimant and both for the respondent. These were my few of the observations as far as the arbitration is concerned, and how should we proceed with this arbitration in relation to the present circumstances. Thank you very much, sir.
Thank you, Mr. Khaitan, for a very wonderful summation. You've raised a lot of food for thought, and you've let me reiterate what you've already said to the participants, that at ICA we need new ideas for the way forward. And so we will await the response of the participants on the emails which we shall share in due course. And also thank you, Sanjeev, for a very engaging session, touching upon some of the key concerns for the commercial world, for the parties, arbitrators, and arbitral institutions today. So, ladies and gentlemen, we will now come to the question answer session. And this is your opportunity to raise issues of importance with our experts. If you have a question, you can still submit it online in the place provided in the webinar portal. We have, in fact, already received several questions during the course of the webinar, and so we'll make a start. The first question that has come to us is, it says that you mentioned that this will be the new normal.
So it appears we have lost Mr. Chawla for a while, and we are seeing questions which are coming on screen. And while Mr. Chawla is not here, I'll put that.
Am I still not audible? Am I still not audible?
No, you are audible.
Why is Sanjeev saying that I'm not audible?
In fact, Sanjeev is not audible.
In fact, Sanjeev is not audible.
Yes.
Sanjeev, you have to unmute yourself, Sanjeev.
In fact, Sanjeev is not audible.
Sanjeev is not audible.
Looks like Sanjeev has gone offline right now. So, Mr. Chawla, can you please continue?
Yes, so I will repeat the first question that has come to us, which says that we mentioned that this will be the new normal. Do you believe that this pandemic will dramatically change the approach of the arbitration community in India? towards technology. Now, that question I will throw to Sanjeev.
I'm back. I'm back,
Okay,
Mr.
Sanjeev.
So
Did you hear
you lost me for a...
Mrs. Sanjeev is.
Yeah. So I think you
Sanjeev
lost me
audible.
for a while. I'm not audible?
Yes. Yeah, now you are audible, Sanjeev.
Yeah, sure.
Yeah, you're
So
now audible.
I think
Yes.
this seminar is an eye-opener in the sense that obviously when we will move on to technology, we'll see that the process is not going to be perfect. There would be issues. There would be network connectivity issues. There would be bandwidth issues. There would be glitches. And obviously, it would be always important to kind of have a backup plan. For some reason, my broadband just went away, but we had planned for a hotspot also. So I am now connected through a hotspot. I think this is something which would be needed when we are moving on to adopting new kind of technology and overcome the glitches. Now, as I hear Mr. Chavla say, I think what the question which has been asked is, would this be the new normal? I would say yes, this would be the new normal. I think once you get used to technology and the ease of that technology with which you use kind of get you addicted. We have found this, and I think in my normal workings, many times I found it to be better physically than a physical meeting. So I think once you start using to technology, and despite the fact there are glitches, the ease and convenience which it brings to you, it gets you hooked. And the ease and convenience, obviously, I think in these kind of conceivable time to have a seminar with so many participants, with 3 of the panelists joining from remote locations would not have been possible. So I think many times technology is going to be the only solution. And therefore, this is going to be the normal. Also, we have to keep in mind that this pandemic is not going to end by a particular date. There is no expiry date of this pandemic. This pandemic is going to continue, and there would be restrictions which would be eased, and there is a possibility that the restrictions will again come. So you will definitely need to find an alternative as to how you are going to continue functioning. So for me, Kavla, this would be the new normal. We should get used to it. We should get adapted to it. There would be problems, concerns, glitches. But I think if you look at the overall benefits which technology is going to offer you at the end of the day, I think the benefits would be much, much more than what I think the disadvantages are. So for me, this would be the new normal.
So thank you, Sanjeev. We have another connected question which says, what is the legal framework in India governing the conduct of an arbitration meeting held by 3 arbitrators at different locations via video conferencing? So I may ask Mr. Khaitan to respond to this.
Mr. Chawla, this particular session itself is an answer to that. I mean, you know, this particular session itself is an answer to that. And you know, in international arbitration, when you for an interim order, you know, just an emergency, even interim order, and you require an interim order immediately. And this is a normal practice that, you know, the 3 arbitrators who are in different locations, you make your submissions before them, or you write a letter, or you write a letter to the SIAC. They discuss among themselves and they pass an order. Even without hearing, sometimes they pass an order. So therefore, this will be the new normal. You know, having arbitration through video conferencing, 3 arbitrators sitting in different area, and as Sanjeev rightly said, that this effect of this virus is not going to go shortly if we feel in a month's time or 2 months' time. I think it will take a lot of time. In fact, we were having I was in a webinar with 2-3 union ministers. I was in a webinar with Abhishek Banerjee, and they all had a feeling that this will take minimum a year. You know, the effect of COVID-19 will take, the effect will go minimum a year. People would also not like to travel. People would also like to have the curtail their travel as much as possible, either domestically or internationally. So therefore, I personally believe that arbitration through video conferencing will be the order of the day and will be the future of this of arbitral proceedings. And in India, you know, now the arbitrations are taking place through video proceedings. Court proceedings are also taking place through video proceedings. In fact, recently now all the hearings before the High Court and the Supreme Court are going through either Skype or video conferencing or through Facebook. So therefore, this will be the order of the day. This will be the new future, and I think this will also avoid costs. I mean, this is very, very important. You know, the traveling costs plus the boarding and lodging costs, taking all lawyers to different destinations. These are all very expensive. So therefore, you need to adopt a cost-cutting measure. And one of the way you can do the cost-cutting measure is through adoption of the conducting the arbitration proceedings as much as possible through video conferencing.
Thank you, Mr. Khaitan. We all tend to believe what Sanjeev has just said, that this will be the new normal in due course. So the third question which comes, a very pertinent question, is that what should you keep in mind while carrying out arbitration proceedings through video conferencing? Sanjeev, can you answer that?
Yes. I think what happened on this seminar is something which I will give you the one cue. I think you need to have a plan always ready. So if there is one internet connection not working, then you should have an alternate internet connection. If the VC is not working, you should be able to patch onto a teleconference. So I think one thing which you definitely should accept is that there would be glitches, and there has to always be a plan B in case you are going for a VC. The other thing which you have obviously very conscious is that what are the limitations and advantages of a particular platform you are using? Is the platform compatible with the backend infrastructure which you have or not? They are tried and tested platforms. They are varying ease with which a platform can be used. And depending upon who the constituents of the process of arbitration are, you might either opt in for a very technologically enhanced platform, or a very simple or a basic kind of a platform in case you think arbitrators are not that tech savvy. The security concerns is something which should be kept in mind. The platforms which you are using should, and on which you are sharing the documentation and data, should not be prone to hacking. There should be firewalls which should be existing. And lastly, it might be very useful not to reinvent the wheel. In the course of our webinar, we took you through quite a lot of protocols and guidelines which have been put up by arbitral institutions and CIRB. And obviously, they have looked at these kind of problems, and they have come out with a very, very, I would say, comprehensive and detailed kind of guidelines which can be adopted. So instead of reinventing the wheel every time, it might be a good idea you go to a particular protocol, and there are more than one on an issue, and whatever suits your needs the most, with the limited amount of tweaking which might be required, in fact, in circumstances of your case, you do it. So if you keep these in mind, then in that particular, I think virtual hearings would be as effective, if not better, as our physical hearings.
Okay. Thank you, Sanjeev. The next question I would particularly want Mr. Khaitan to answer, because Mr. Khaitan, you have been associated with the Indian Council of Arbitration for so long, and you are well aware that we have in our rules the fast track arbitration clause, the fast track arbitration procedure, but it has been seldom used by the parties. So in the current circumstances, the question that has been raised is, do you expect to see a rise in the number of parties opting for document-only arbitrations as a result of this crisis?
Mr. Chawla, in my presentation today, I have stressed upon that we have to think to have a fast track arbitration where we should have a threshold limit of a claim amount, and all those arbitration having a threshold limit of a particular amount. We can think of 1 crore or 2 crores or 3 crores, and we should decide that all those arbitration be on the basis of the fast track arbitration and only with the sole arbitrator. I'm saying so for a reason. I'm saying so for two reasons. First of all, there is a total financial crisis. There is a deep depression. There will be, the future is that there will be a total dip on the GDP. There will be a dip on the profitability of the companies. Therefore, the only alternative is that you have to cut costs. Now, one way to cut cost is that we have an arbitration in a manner so that the arbitration is done in a time-bound manner, and we able to deliver the award within a time frame, and the arbitration proceedings are not very lengthy. And the parties would be very happy, if I may say so, with utmost respect, if they see that they will have a justice delivery system in a very short period of time. It will also cut their cost. It will also, and which I will also add here, that is those arbitral proceedings, no lawyer should be allowed to appear, which number of associations have, on a threshold limit. So therefore, the parties appear themselves. They don't have to go into the jugglery of various provisions of the law. They plead their case on the basis of the documentary evidence, and most of the cases can be decided on the basis of the document. And in any event, they have a right to make a notes of argument and submit a notes of argument to the arbitrator, which they can take a help of a lawyer in preparation of that notes of argument, which can take the case laws and other legal issues into consideration when they submit the notes of argument. So therefore, I personally feel that doing a fast track arbitration within a threshold limit and having those arbitration through a sole arbitrator would be the most convenient way to deal with the present situation.
Thank you, Mr. Khaitan. I think yes, whatever you've said is will become the order of the day now. We have already breached the time, and I'm afraid we will just take one last question. This is which has come to us, and I will throw it at Sanjeev. This is on Section 29A of the Arbitration Act. It says, how do you see parties managing the timelines under the Act, given the lockdown and the uncertainty created by this crisis in general? Very, very critical question, Sanjeev, for you to answer.
So I would say the situation is unprecedented, and obviously parties as well arbitrators and institutions were not really geared to cope with it. It has been some time, and there are things which are getting in place. So some kind of action, according to me, would be needed and should be needed. But it is going to continue for quite a long period of time. I don't think that in those kind of circumstances, 29A extension should be granted easily. I think in case a case is at an evidentiary hearing and that is getting adjourned, that can be justified. But in case there was a case in which only the timetable of the hearing was to be adopted, that is something which is possible even by emails. You don't even need a VC for that. That is something which can be done by exchange of emails, etc. So I would say that in genuine and reasonable cases, I think court should be conscious of this and should be granted extensions, etc. But I think it is important also to send the message that this unfortunate event which is happening around us in the world would not be taken as an excuse for you to delay the proceedings. So I think there is a right kind of a balance which is required to be struck. And therefore, at the end of the day, nobody can pass a generalized comment, but it has to be on case-to-case basis.
Thank you, Sanjeev. And let me now turn to the participants and thank them. Thank you for your questions. These questions would actually made the webinar very, very interesting and interactive and enlightening. So to other questions, we will respond offline as we are not able to deal with them today. Please send your questions to our dedicated email ID, which we'll just share with you post this webinar. And I hope all of you found this webinar very interesting and worthwhile investment of your time. We will make an attempt and endeavor to come back to you in due course of time with another more interesting webinar. Thank you for your attendance today, and we look forward to be of service again at future webinars. Thank you. Thank you. And thank you,
Thank you, everyone.
Thank you, Mr. Khaitan. Thank you, Sanjeev.
Thank you. Thank you.